Hello. Quite some time ago on this channel, we were talking about the de facto spouses, the conjoint de fait, or the common law spouses in the other way, meaning that there is no registration, there is no formality to be observed. People simply live together, and that's it. And then there was a question: what's the difference between the civil union and marriage? And I would like to draw your attention to the fact that I'm going to talk about this difference or similarities in Quebec, according to the Civil Code of Quebec, because this might be different depending on the province in Canada or the country all over the world. So we are talking exactly about Quebec. In Quebec Civil Code, the idea, the notion, the concept of the civil union was introduced sometime after the Civil Code itself came in force. And the idea was to provide rights, well, one of the major ideas, to provide rights to same-sex couples, which did not have those rights at the time, or at least it was not clarified as it was done later by the Supreme Court of Canada and the Canadian Parliament. So at the time, mostly the idea was to duplicate the same rights, obligations, the same property regime for those couples who cannot marry in the usual way. Since then, the situation changed, so nowadays same-sex couple can marry in the very same way as anybody else, at least here in Canada and Quebec. So the use of the civil union regime diminished in a sense that lesser and lesser number of couples use it, but it's still there in the Civil Code. And if you look at this table of contents, you could see that first of all, it's clear that the articles were added. You see like 5 to 1.1, which means that it was an addition, a modification to the code. But then if you open it, wherever you can find the Quebec Civil Code online, you could see that the articles are more or less mirror each other. The legal difference is that marriage itself and divorce is governed by the federal law, the Divorce Act, while the civil union, this civil union, is a specific regime for Quebec, so it's completely governed by the Civil Code of Quebec. But again, the Quebec legislature tried its best to make it as close to marriage at the time as possible. So, but for some specific moments, the regime is very much close, as long as the couple is in Quebec. You can read this beginning of those articles, starting with 5 to 1.1, the requirements and the very idea. And when you look at the 5 to 1.2 second paragraph, you can see this notion of the religious freedom, which again reflects the idea and those debates about same-sex couples. But again, nowadays, and even then, the civil union is equally available to everyone who wants to get into this regime, as opposed to getting married. And probably the only real advantage which still exists is that one can dissolve this civil union easier, especially if there are no children, than a regular marriage. This one can be dissolved by agreement, but we'll talk about that later. Let's have a look at the similarities. To get in Quebec again into a civil union, one has to be unmarried, like single or divorced or widowed. So same thing. In the same way, a civil union cannot be registered with a close relative. It should be registered, and the same organizations and same persons, same officials perform the formalities. The rights and obligations are virtually the same, or very much similar at least. And again, it is valid as it is in Quebec. So if the couple in the civil union goes outside of Quebec, the legal status of that couple depends on the recognition of Quebec's civil union, if there is one, in that particular jurisdiction. Same as with marriage, before or during this union, a couple can enter into a contract as to the property. It can be property separation or otherwise. And the same as with marriage, there is an official document attesting to that. So in that sense, if a couple lives in Quebec and continues to live in Quebec and just all the legal business happens in Quebec, it's more or less the same. The difference, the actual difference, comes when there is legal business outside. As I mentioned, this union can be simply not recognized in some other jurisdictions. So in those jurisdictions, the couple is not officially a couple, just the de facto spouses, no more than that, which might entail different legal consequences when it comes, for example, to a situation of mental incapacity, or to the hospital visits, or to legal tutorship over children. Well, depends on the situation, of course. Adoption, especially when it comes to international adoption, because in many jurisdictions such a couple will not be even fitting into requirements because it won't be like a married couple. And of course, there is a possibility to get into a situation when two persons got into a civil union in Quebec, then one of them, for example, left, or both of them even left, separated, and being technically not married in some other jurisdiction, they might enter into some legal marriage in those jurisdictions, or one of them could. And then, at least in Quebec, there might be a situation of not exactly double marriage, but similar to that, especially if it comes to some kind of estate, succession issues, inheritance, applications for spousal support, child support, and so forth. So in that sense, good old marriage is still a more complete regime than the Quebec Civil Union. But as I mentioned before, if a couple envisages to get some additional freedom as to dissolution of the union, and if it's done by agreement, of course, because otherwise the way it's still goes to the court. But if there is an agreement and if there are no children, then such a union can be dissolved by simple agreement, well, properly registered again, of course. So this is the difference as it is now in Quebec. Well, the general overview, of course. And again, as always, if you have your particular situation, of course, you should consult your own lawyer. Thank you and have a nice day.